Hi, my name is Chujun An. Today I will explain about delay, liquidated, and ascertained damage and extension of time in construction contract in Malaysia. First, I will explain delay. Delay happens when a construction project cannot be complete within the agreed completion date. There are generally two types of delay, which are contractor delay and employer delay. For example, if the contractor is slow, it is contractor's fault, but if the delay is due to variation order or late instruction by the employer, then it is not the construction's fault. Next, I will explain liquidated and ascertained damage, or LAD. LAD is a compensation that the contractor must pay if the project is completed late. The amount is usually stated in the contract, for example, 100,000 ringgit per day. In Malaysia, LAD is commonly used in contracts such as PAM 2018 and PWD 303A. The purpose of LAD is to avoid dispute because the amount is already agreed earlier. If the contractor delay without valid reasons, LAD will be imposed. Now, I will explain extension of time, or EOT. EOT allows the contractor to extend the completion date without paying LAD. This can happen when the delay is caused by factors beyond the contractor's control, such as bad weather, variation orders, or force measures. Under PAM 218, the contractor must submit a notice within a specific time, usually within 28 days, to apply for EOT. If the EOT is approved, the contractor will not be penalized by LAD. Next, I will explain the relationship between these three concepts. If there is a delay, the contractor should apply for EOT. If the EOT is approved, not LAD will be imposed. However, if the EOT is not approved, then LAD will be in charge. So the relationship is delay, next EOT, next if not EOT, then LAD. Now I will explain two related case law. The first case is Silva Kumar versus Tyagaraja. In this case, the court held that LAD must be a genuine pre-estimate of loss. If not, it may not be enforceable. The second case is Cubic Electronics versus Mass Telecommunications. The federal court decided that LAD is valid if it is a reasonable compensation, even if it is not an exact calculation of loss. Lastly, there is an important participant called the prevention principle. This means the employer cannot claim LAD if the delay is caused by the employer himself. In conclusions, delay, EOT, and LAD are closely related in construction contract. EOT protects the construction from unfair penalty, while LAD protects the employer from delay. Thank you.